Good morning, salam sejahtera. Our respected guest speakers, Dr. Michael Shaper, Deputy Chair of the Australian Competition and Consumer Commission, ACCC, Yang Berusaha Puan Sheila Dore Raj, Chief Executive Officer of the MYCC, guests and participants, Tuan-Puan, Div-Div Kehormat, dan para hadirin yang saya hormati sekalian. Selamat datang and welcome to today's talk titled, Does the Competition Act Help or Hinder SMEs? Yang Berusaha Puan Sheila Dore Raj, the CEO of MYCC, will begin the first session with her talk on the implications of the Competition Act 2010 on SMEs. Before that, a little background on Puan Sheila. Prior to being the current CEO of the MYCC, Puan Sheila was the head of the Interim Competition Unit in the Ministry of Domestic Trade, Cooperatives and Consumerism, MDTCC. She was tasked with setting up the Competition Commission as well as laying the foundation for the implementation of the Competition Act 2010, which came into force this year. She was formerly the Under-Secretary of the Policy and Planning Division of the MDTCC, where she was a key member of the team formulating the policy and the subsequent drafting of the Competition Act. She has been involved with the subject matter of competition policy and law for the last 7 years. She was also chair of the ASEAN Experts Group on Competition from 2009 to 2010, overseeing various capacity building programs and policy dialogues, as well as in related competition issues held around the region as well as in Malaysia. She has also presented several papers at various international and national seminars, as well as contributed to several articles in magazines and books, including an UNCTAD UNCTAD publication on competition. Puan Sheila also has extensive experience in international economics and government finance during her tenure at the Ministry of Finance. Without further
Good morning, ladies and gentlemen. Thank you, Rowena, for that introduction. Thank you for being here. I understand that there's quite a bad and massive jam out there, because I've just got a few SMSs to say that they are stuck on the highway. So I believe that people will come in as they arrive here. Okay, today we have a special guest with us, Dr. Michael Shaper, who is an expert in dealing with SMEs and competition law. So we thought, we meaning the Malaysia Competition Commission, thought that this would be an ideal working relationship between the ACCC, which is the Australian Competition and Consumer Commission, and the Malaysian Competition Commission to actually engage the SME community in Malaysia in order for us to explain the implications of the Act and what SMEs can actually do to help themselves as well as to prepare themselves as the law gets implemented in a more vigorous and aggressive manner. We are working here today with the SME Corp, and I'm grateful to the SME Corp for lending us, giving us this opportunity. And we are hoping to have a road show next year so that we will be able to engage the SME community not only in the Klang Valley, but also throughout Malaysia, including Sabah and Sarawak, because I think our presence, especially in Sabah and Sarawak, has been very minimal. And so I thought that we should work very closely with the SME Corp to get this thing across to all sectors of the SME Corp. I know a lot of you would have been privy to the briefings that we have been giving throughout last year and this year, but at the expense of boring some of you to death, I would still want to take you through some of the major issues in the Act in order for me to tell you, the SME community, what are the issues that you really need to be aware of. MyCC has actually, and I'm sure you know that we have already given a proposed decision to the Cameron Highlands Floriculturists Association, and they have come to us, and I will share with you their concerns. We have also engaged the Ministry of Agriculture. We have gone to, the Deputy Minister actually called us, and he actually had a heart-to-heart chat with us, and he actually told us some of the concerns of the SMEs, and he actually pleaded with us, and he actually asked us, you need to do something for the SMEs. So here we are today, and Dr. Michael will also share with us what he has done for the SME community in Australia, and we hope to work this through together. Okay, some of the implications here. This would be the scope of the content of my very brief briefing. I'll just quickly take you through the scope of the law, the main prohibitions, because you need to be aware what are the main prohibitions and the issues that SMEs need to be aware of, okay? The CA 2010 enforcement and SMEs, and of course a conclusion. Okay, the scope of the law. What is the application? I've highlighted those bold words, all enterprises. It applies to all enterprises engaged in commercial activities other than those 3 bullets that have put down, okay? So it applies to all enterprises. Does not matter whether you're big or small. It applies to all enterprises as long as you're engaged in a commercial activity, okay? So these are the key words that you need to be aware of. Of course, it does not apply to any activity directly or indirectly in the exercise of governmental authority. We know that a lot of people have told us that this is a very broad clause, but the MyCC will interpret it in a very narrow manner. Any activity conducted based on the principle of solidarity, again working together, not for the interest of, not for economic interest or for profit making, okay? And any purchase of goods or services not for the purposes of offering as part of an economic activity. This is really the government procurement part of it. So if government procures goods and services for, with the intention of providing it for the public or the rakyat, then that is not considered a commercial activity. Okay? So really the CA, that is the Competition Act 2010, it really focuses on the conduct of an enterprise, okay? So it does not look at the entity at all. That's why we do not have the merger and regulation in place, okay? So it really looks at the conduct of enterprises in the economy, in the business environment. So the 2 main prohibitions, okay? The anti-competitive agreements and an abuse of dominant position. Okay, what is an anti-competitive agreement? This is a horizontal or vertical agreement between enterprises which has the object or effect of significantly preventing, restricting, or distorting competition in any market for goods or service is prohibited. So if as a small enterprise, you have a horizontal agreement between the enterprises, that is an agreement which is prohibited under the Act, okay? So like the Cameron Highlands Floriculturist Association, they had an agreement between the enterprises to fix prices, okay? It was a blatant price fixing agreement and it was announced in the newspapers. And when we went to investigate, we found that all of the florists or the few florists or the random check on some of the florists and outlets that we checked on, they had all these signages in their premises which says that this association has decided or has given the instruction that all prices of flowers will increase now by 10% effective from blah, 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 okay? So that was an agreement which was agreed upon by the members of the association. Although the members of the association who were present at that meeting were not the full members, but yet the rest of the members who were not present accepted that agreement, okay? So that is the kind of a horizontal agreement that we are talking about. You talk about a vertical agreement, it is an agreement between a manufacturer, a distributor, and a retailer, okay? So it is this way. And this kind of agreements, the MyCC will look at the effects of this agreement on the market. So if, let's say, you're an SME and you are not significant enough, okay? So the underlying word here is significant. you really do not have to worry, because you will not affect competition in a significant manner, all right? So these vertical agreements, we need to look at the effects. What is the effect of this agreement on the competitors, okay, on the market? So these are the agreements deemed as anti-competitive under Section 4.2. These are the horizontal agreements that SMEs must be aware of. Price fixing, limiting or controlling production, market access technology or investment, market sharing, bid rigging. So even if you are small and you undertake these kind of horizontal agreements, it is a per se infringement. It is an infringement under the Act. So if you are pleading with the MyCC to ask for a carve-out or an exemption, we cannot exempt you because these horizontal agreements are infringements under the Act, okay? So as I've illustrated in the Cameron Highlands case, even if you're small and you're fixing prices, you have an agreement to fix prices, that is an infringement under the Act, okay? And you cannot be excused from that. Same with market sharing. You're sharing your market, you decide that, you take care of Penang and I'll take care of Ipoh and X takes care of Johor. That is really sharing your market, all right? And of course, you know what is bid rigging? When all of you in a tender exercise, let's say A, B, C, D, and E, undertakes to bid rig, that means all 5 of you agree that, okay, the government is going to open a tender for building schools or houses, okay, and you are the 5 major developers. Maybe in your case, you are just an SME, let's say supplying some products, okay, and you are 5 suppliers. So you agree among yourselves, okay, so A, I think, you will have to win the tender this time, so you bid for this price, and 4 will bid in such a way that, A will definitely win the prize, win the bid. And the next time round, B will be the one who will be offered the opportunity among the 5 of you, and then B will win the bid. So this is called bid rigging. You agree among yourselves who will win the bid for that particular project. Okay? So really, these are the horizontal agreements that you need to be aware of. Okay, other types of agreements are prohibited only if they significantly prevent, restrict, or distort competition in any market. So I emphasized just now that if you are not significant in any market, you do not have to worry, okay? So safe harbors for you: if the combined market share of the parties to the agreement is less than 20% of the relevant market, so together, if you only represent 20% of the market share, you don't have to worry because you're not significant. And for non-competitors, all of the parties individually has less than 25% in any relevant market, okay? So these are the safe harbors that you need to take away with you. So we have put out our guidelines on Chapter 1, Prohibition. If you need more explanation on what these are, please refer to it on our website. Okay. Abuse of dominant position, that's the other infringement under the Act. An enterprise is prohibited from engaging, whether independently or collectively, in any conduct which amounts to an abuse of a dominant position in any market for goods or services. Then you are abusing your position, okay? So a dominant position here means a situation in which one or more enterprise possess such significant market power. Okay, these are some of the examples, of directly or indirectly imposing unfair purchase or selling price or other unfair trading conditions on suppliers or customers, that is excessive pricing, raising a rival's cost. Those are some of the examples. Market foreclosure and exclusion means you are limiting or restricting your production, market outlets or access, technical or technological development or investment to the prejudice of consumers. Refusal to supply means you just refuse to supply. Price discrimination, you're applying dissimilar conditions to equivalent transactions. Tying you're making the conclusion of contracts subject to acceptance by other parties of supplementary conditions, which by their nature, according to commercial usage, have no connection with the subject matter of the contract. So, though the two products have no relevance to each other, all right? For example, if you want to buy a fridge, somebody asks you to buy a dining table. It's not at all related, okay? So that is tying. Predatory pricing it below cost so that you push or you eliminate competitors from the market, and when there are no more competitors, then you increase your prices slowly. Market foreclosure or exclusion, you're buying up scarce supply of intermediate goods or resources required by a competitor, okay? So these are some of the examples of a dominant position, person in a dominant position. Okay, so basically, those are the two prohibitions that I want to bring to your attention. Okay, Competition Act and the SMEs. So again, I want to emphasize here that Section 4.2 infringements apply even to SMEs, okay? So it does not mean that you are small, so you have to ignore the provisions in this act. Engaging in such prohibited conduct is considered as hardcore cartels. So those four conditions, the price fixing, bid rigging, market sharing, and what was the other one? Maybe if I go back and emphasize that fact. Okay, price fixing, limiting or controlling production, market access technology, market sharing, and bid rigging. These are all hardcore cartels, okay? Okay, and cartel activities significantly harm consumers and the economy. I think research has shown that cartels have increased the price of goods and services by like 35%, okay? And many countries, and I'm sure Dr. Michael Schipper will share with us, they have imposed heavy financial penalties, including imprisonment for cartel offenses, okay? So here in Malaysia's case, this year is the year where we introduced the law. It was enforced come 1st January 2012, and we issued a press statement to say that any infringements that anybody found guilty of an infringement will not be fined this year. We will just ask you to undertake some remedial actions. So that's what we have done in the Cameron Highlands case. We have not fined them, because if we had fined, their turnover for the financial year last year or the year before was something like 87 million. And if we had slapped a 10% fine, which is the maximum fine, we could have got 8.7 million for ourselves, okay? So for this year, it's all remedial action. We've got only, another 1 month left. Come January 1st, 2013, penalties will be enforced. Okay, so I've also highlighted some of the safeguards for SMEs, low market shares, less than 25%, unlikely to significantly restrict, prevent, or distort competition. Dominant, if you're less than 60%, it's very rare for you to be dominant, okay? So again, I need to emphasize that this does not apply to price fixing agreements. Now this one, should SMEs, this next few slides are questions that I want to ask you, I want to pose to you, I want to share with you. Should SMEs be excluded from the Competition Act 2010? There has been requests for leniency and automatic exemption, okay? I have a letter on my table, which I'm thinking, how do I address this letter? It came from the Prime Minister's office. It is an appeal by the associations for the MyCC to consider an exemption from SMEs. And many of the reasons cited here, I'm sharing it with you, says this. CA 2010 has an adverse impact on SMEs. I'm not sure why. Why is there this fear from SMEs that it has an adverse impact on SMEs? CA 2010 is a burden to SMEs. Hi, when I read this, it's a burden that I don't want to burden enterprise. I don't want to burden businesses, It's quite a serious allegation. SME's capacity not big enough to pose a threat. Yes, sure. I did say that even only when you're significant, you may pose a threat. The need to exchange information on prices and markets. This is a real problem for businesses. It's a real problem for me too, because SMEs are telling me that they need to exchange information. They need to exchange information on prices, on costing, and whatnot. So how do I address this situation? Even the Deputy Minister of Agriculture told us, you need to find a solution for the SMEs, because these small farmers, where do they go to compare prices? Who is there for them to supply the prices for them? It's only the middleman there, who goes out there and tells them this is the price that you have to quote. So what is the medium? What do we do? Do we have to set up a third party where the data is collected for SMEs? What do we do? Maybe Dr. Michael Schaefer, you have to help me here. I'm desperate. I don't know what to do, okay? But I know that when I'm discussing issues with the SMEs, there's a little bit of confusion between sharing price information and being allowed to increase your prices. For example, the CHFA, the Cameron Highlands Floriculturist Association, they came and explained to me, or not explained, they came and they talked to me. They said that you don't understand. You are not in business. You are just a government servant. But prices have increased. The cost of production has increased. So I told them, I'm not worried about price increase. You are allowed to increase your price. You want to increase it to 20%, 30%, it's fine with me. But don't collectively agree to increase the prices by 10, 20, or 30%. I said, that is something that you all need to understand. Sharing information on prices and being allowed to increase your prices. Two different issues, okay? But this is something I think we need to really go down and explain to the SMEs. But really, exchanging prices, even the Malaysian Association, the Automobile Association, they have a real problem. And I think all associations in Malaysia, or maybe all around the world, have this issue with them. Because the very fact that there is an association is for competitors to gather information about prices. So now if we take away that role from them, associations are asking me, then why do I need to exist as an association? So I tell them associations have other roles to play. You can set your standards, ethical way of doing business, networking, so many other things. But yet they say exchanging prices is the most important function for an association. Okay? And the other question or issue posed to us was traditional enterprises have lost market values. Pricing system no longer available. So they seem lost. SMEs feel lost, And I feel sorry for them also, because how much more can I explain to them? But rest assured that we will try to find a solution for this major issue. So really, SMEs should use the competition law as a sword or a shield. Okay, a sword, why? Because if larger enterprises are using anti-competitive means to do business with you, you can always report them to the MyCC. Okay? It could protect SMEs by deterring bigger companies from adopting abusive or other anti-competitive practices. And as a shield, you yourself have your own compliance programs. Make sure that you're doing business in a manner which is not anti-competitive. Okay? So the possibility of using competition law to protect market position or market aspirations in the face of troublesome competitors or suppliers. So you really don't look at the Competition Act as a threat. Don't say that it has an adverse impact on you. Do not say it is a burden on you, okay? You use it as a sword and a shield. I think in our roadshows, we have emphasized this fact. So these are some of the frequently asked questions, okay? How do SMEs benefit from the introduction of competition law? Okay, as I said, use it as a sword or a shield. You can, the Competition Act is here for you to enable yourselves to become competitive in the market so that you can enter the international markets. Question 2, will the introduction of competition law impose unnecessary constraints on business models and practices of SMEs and affect their flexibility? The purpose of the Competition Act is to protect competition, not to restrict business models and flexibilities of SMEs. So you need to understand the principle of a competition law, okay? And I said, you probably lack market power. You're not dominant enough to be in a dominant position, okay? So generally, information exchanges between SMEs are unlikely to have significant anti-competitive effect, but you need to examine the kind of information that you are sharing. Given that SMEs do not have market power and that their actions are unlikely to have the effect of significantly preventing, restricting, or distorting competition. So really, we really need to take stock of the situation, okay? Because you see small firms make up 19.4% and micro enterprise make up 74.9%, okay? So we really need to stock take of the issues and the practices of SMEs before we can propose an exemption for SMEs. I'm not saying that we are going to, but I'm saying these are the issues. Some SMEs are worried that after the introduction of the CA 2010, big enterprises may make unreasonable complaints against SMEs or even take civil action in the courts to disrupt their operations. Don't have to worry because we do not scrutinize frivolous complaints, okay? And it is really quite difficult for a private party to adequately discharge the burden of proof. It's really difficult because here I'm talking about we are talking about the private right of action. I think the SMEs are also afraid because in our law we have allowed a private right of action, which means that private enterprises can actually not come to MyCC but to actually go straight to the courts to lodge a complaint. But really to prove otherwise, it's really a difficult task, okay? And finally, in order to get volume discounts, SMEs may engage in joint procurement activities. Would this violate the CA? Joint procurement activities are unlikely to raise any competition concerns because it's really economies of scale that we are talking about. Okay? So in conclusion, I would like to say that contribution of SMEs to our economy is really vital, as you saw the statistics. Okay? And MyCC believes that the CA 2010 will serve as a tool to help SMEs rather than hinder the growth of SMEs. We are open for discussions and consultations. So please do not take the Competition Act as a burden to you. Do not think that it has adverse impact on the SMEs. Thank you very much.
Okay, next we have Dr. Michael Shaper, Deputy Chair of the ACCC, who had also generously taken some time out in his busy schedule to give today's talk. A little bit of a background on Dr. Shaper. He brings with him extensive experience in the area of small business, also known as SMEs to us, through his previous roles as ACT Small Business Commissioner, Dean of Murdoch University Business School in Western Australia, and Head of the School of Business at Bond University in Queensland. A previous president of the Small Enterprise Association of Australia and New Zealand, he has been a member of the board of directors of the International Council for Small Business and has held the Foundation Professional Chair in Entrepreneurship and Small Business at the University of Newcastle. In addition to his extensive academic career, Dr. Shaper has worked as a professional small business advisor and as the owner of a number of new business startups himself. In 2009, he was recipient of the National Small Business Champion Award by the Council of Small Business Organizations of Australia. The author of or co-author of 8 business management books, he has been a regular columnist in a number of national magazines, newspapers, and journals on business issues. He has also worked as a policy advisor to government at both the state and federal level. Dr. Schaefer is also a member of the ACCC's Enforcement and Adjudication Committees. Phew, a very long list. Now, please welcome Dr. Michael Schaefer.
Saya ingin mengucapkan terima kasih kepada Competition Commission di atas jembatan untuk memberi ceramah di negara ini yang indah. Permisi dulu, that's about the limit of my bahasa. But thank you. I did, as has been mentioned, want to talk about a number of issues today. And the principal issue that I wanted to discuss was the one that Sheila touched on towards the end of her discussion. And that is, are the new competition laws going to help or hurt the small business sector overall? And I'm going to draw largely on our experience in Australia, but also some evidence from countries such as the United Kingdom to look at this issue. And in doing so, I really want to look at a number of issues. First of all, why we have these regulations and why we apply them to small businesses. Are small businesses the same as large businesses when we talk about competition issues? And if they're not, how do we deal with that? Is competition law going to hurt individual small businesses or help them? And for the small business sector as a whole, is it going to hurt and help them? And finally, what can small business SME associations do to improve the business environment, their relationship with the competition regulator? Again, based on some evidence that we have, as well as some ideas. My own experience, I'm neither a lawyer nor an economist. I've spent 4 years now as the Deputy Chairman of our competition agency, because in Australia, by law, it's a requirement that there be a Deputy Chair with a background from the small business sector. So my conclusions are as much coming from the small business, the SME framework, as they are from the competition regulator. I'm very happy to take, I know there's question time towards the end, but I'm also happy to take any questions that might arise as we go. If there's something that's not clear, and this can be a little bit confusing at times, please feel free to ask. First, the small business sector in Malaysia. Let's just get a bit of a handle on the size of what we're talking about, and let's also look at this issue about whether or not Malaysia is different to other countries because it has more small businesses than other countries. Well, as you can see behind me, Malaysia has a very clear structure of micro businesses, small businesses, medium-sized ones, and right at the top, a very small number of large businesses. And many people look at this and say, well, clearly this country is different. Clearly there are more small businesses here than is the case anywhere else. And because of that, perhaps small businesses need to be treated a little bit differently. It's an interesting pyramid. Micro enterprises, very small ones, each of them individually don't mean much. Each of them could be one person, typically two people, running a business together. Very, very small, each of them, their impact on the marketplace, very small, but when you put them together, they count for a lot. And as you get bigger, of course, then you end up with the other end where you have a very small number of large private sector firms, and they employ roughly about half of all the private sector workforce. So the small businesses individually don't mean much, but together they mean an awful lot. Well, is this different? Is Malaysia unique? Well, not really. I've used Australia not only because obviously it's where I come from, but because our populations are roughly similar. Malaysia has about 26, 27 million people. Australia has about 21, 22 million people. And you can see there that although the numbers of businesses registered are a little bit different, the pyramid is basically the same. Like you, we have an awful lot of micro businesses, then we have a reasonable number of small businesses, a smattering of medium-sized firms, and only a very small handful, really, of big businesses. We have roughly about 2 million businesses registered, and the Malaysian figure is about 670,000. But the pyramid is still the same. Both countries are countries full of small businesses. Both of them are countries where individual small businesses have a very small market share, but when you put them together, they account for an awful lot. And if you think this is unusual, think about this. Indonesia has more micro businesses than there are people in Malaysia. They have over 30 million micro businesses. In fact, if you look through ASEAN and you look through the Asia-Pacific region, you can see that micro businesses and small businesses, SMEs, and in fact I'm leaving out the M in SME, I'm really focusing on the S. The small and micro businesses are the vast proportion of all the businesses we've got. So the problems we have here and the concerns that you may have about how does a competition law going to affect us? Well, if you look at that list, you'll see countries such as the USA, such as Singapore, such as Korea, Japan, Canada, that have all had established competition laws for decades. And their small business sector hasn't shrunk, hasn't declined, hasn't collapsed because of the existence of a competition law throughout it. The issues we face here are in some ways very similar to what everyone else faces as well. It's a very interesting figure, isn't it? Right around the world, everywhere you go, and I've only given you a selection of businesses here, a selection of countries, wherever you go in the world, it's almost always the same. Small, micro and medium businesses, SMEs, account for about 95 to 99% of businesses in every country in the world. So that's a bit of a sense about what are we dealing with here. We're dealing with a lot of businesses, we're dealing with a lot of micro businesses, we're dealing with a lot of small businesses, and we're dealing with very similar issues to the rest of the world in some areas. The second issue, though, is why are we doing it? What are we trying to do, and why are we doing it? Well, the bedrock, the basic idea for a competition policy is to create a fair trading environment in which businesses can thrive, provided they are successful, provided they have something to offer that can work in the marketplace. And to do so, ironically enough, we've realised over the last 50 years right around the world that in order to have a free market that works, you also need to have rules for that free market. In some senses, it's no different to playing a sport, is it? You can't play football if you don't have a clear set of rules that everyone knows and everyone has a chance, every team has a chance to compete on equally. The best ones succeed and those that don't, well, at least they didn't fail because they didn't know the rules or the rules were set up against them. So we set it up to produce, as I've put up there, particular market outcomes. We want really markets that allow the best firms, the brightest firms, those with the most innovative products, those that meet a customer, a consumer need to thrive. And for the inefficient ones, they have a chance, and if they don't succeed, so be it. And we do it through a variety of tools. I've put a list here of what you find around the world. Not all of them are found in the Competition Act here in Malaysia. For example, Mergers and acquisitions are not dealt with by and large in the Malaysian context, but they are in many other economies. Similarly, in places such as Australia, we have, as part of our competition regime, the rules about consumer protection. But again, that's not always the case. In Australia, the competition regulator also takes responsibility for certain industries where there are natural monopolies or the market doesn't work particularly efficiently. But if we turn to the rest of the list, we can see that much of that is very similar to what Sheila mentioned before. For example, making sure that policing of anti-competitive behaviour, the cartels, the price fixing, the market collusion, the misuse of what we call market power, abuse of dominance, as Sheila referred to it, whatever the term and however it's defined in your own country's law, it's the same thing, about an unfair advantage. Are some businesses using their power to get an unfair advantage over other ones? And don't think it doesn't happen. Businesses try and do it as part of a very clear strategy at times. How do I make sure I've got the power, I've got it? Why wouldn't I use it unless the law says I can't do so? And that's why we need the law there. We're not saying that businesses can't be commercial, they can't use new strategies, but what we are saying is they can't do it unfairly to crush rivals by abusing or misusing the power they have in the marketplace. Now, the big picture, is this going to hurt or help small businesses? Well, as the introduction noted, I did spend several years working as an academic, and I actually spent a bit of time not only running business schools, but also managed to have the opportunity to come and teach here on a number of occasions. So I've got a slide here about the theory. Don't worry, there'll be no test at the end of it. But the theory is important, and the theory is very clear. Free markets, fair markets, open markets help particular types of businesses to succeed. They allow new businesses a chance to try and make a mark when they might not otherwise. They allow entrepreneurs to bring innovations to the marketplace. They give the public, the general consumer population, more choice. They are one of the mechanisms through which we get new innovations in a country. And it will also mean that what we get there is an environment in which businesses come in, they compete. And the outset, though, of competition, some will fail and some will succeed. Interestingly enough, again, right around the world, every year about 10% of businesses in most countries stop trading. Every year about 10% stop trading. And they stop trading for a variety of different reasons. Some of it because they can't compete in the marketplace, some of it because the owner decides they want to finish, whatever the reason. But we have to think about that one in mind. One of the reasons that small businesses sometimes are a little bit concerned about a competition policy is, will this mean, as one of Sheila's slides mentioned, will big business use this as a tool to drive us out? Will it cause businesses to fail? Well, businesses are failing every day, and rather brutally, businesses failing or succeeding is part of the free market, and it's what inevitably is going to happen. The question we have to ask ourselves is, do we actually want to protect businesses from failing? And I'll come back to that in a minute. And don't forget, sometimes small businesses are actually better at competing than big businesses. There are times when being small is an advantage, not a disadvantage. Think about this. If you are a small business, you know your customers very well. You have a close personal relationship with them. You have a degree of flexibility that a big firm doesn't have. You don't have all the products or the services, but you can carve a niche out in a way that a big firm can't do. Many small businesses, many micro businesses exist because they find little niches and they do them very well, and they service a small group of customers, and they know their customers extensively. And they make a good living for themselves, for their owners, for their staff, and for their family as well. And don't forget, one of the other reasons why we want small businesses to succeed are because some of them are going to be the next generation of big businesses eventually. We don't know which ones, but one or two of them every year will eventually grow to become a large firm. And we also want them because that's often where the new products and the new innovations come from. Established large firms don't go looking for innovations if they don't need to. It's when their competitors, their small upstarts, start nipping at their heels and start putting out new choices, and customers start thinking, I like that better, that big business starts thinking, I need to be a bit more responsive. So without our small businesses, our large firms would be even less responsive to what we need. But it's not all, obviously, it's not all that easy. Just because I've said that they can be flexible and nimble doesn't mean that they're always going to have everything on their side. For example, small businesses, as you see there, have a very limited share of products and markets. Think about this, if you are a small business and you lose one customer, it has a much bigger impact on you than if you're a big business. If you are a small business, you only have a very limited share of the market, and you do have to be very wary about what your competitors are doing. It is hard if you are starting up to get access to supplies and equipment, raw materials, goods. It's hard to find staff. It's often hard to find credit, although I do note that Malaysia actually ranks #1 on the Doing Business Global Survey for ease of credit for SMEs, but it is still hard to get there. It's very hard to get legal advice and information to work out what can I do and what can't I do. Being small has both advantages and disadvantages. And it has disadvantages and advantages for both individual businesses and the SME sector as a whole. So first of all, I just want to hold that thought. When we ask, are competition laws in Malaysia going to affect small businesses, SMEs, we need to think about it in two ways. How is it going to affect my business? And secondly, how is it going to affect the SME sector as a whole? So I'm going to come back to that. But before I do, I just want to show you this slide here, which fortunately you've got the sheets, so you can probably see it in a bit more detail. But here's a summary of the differences between big firms and SMEs when we talk about competition law. SMEs have a small market share, big firms obviously have a large one. SMEs have a very limited number of customers, large firms tend to have a bigger number. SMEs find it harder to get legal advice that suits their needs, and they're less inclined to want to spend money. Large corporations don't have a problem with that. Your chances of failing as a small business are pretty high. If you're an established large firm, your chances of failing are very low. How much do small businesses know about their customers and competitors? Most of it they pick up by rules of thumb, what they learn themselves. Large corporations, on the other hand, have fairly extensive, sophisticated databases and knowledge management. So let's just remember this. Small businesses do compete in the marketplace a bit different to big businesses. So they compete differently. So the question here, and this is the one that Sheila mentioned as well, talked about the letter on her desk there asking for exemptions, for leniency, for basically a carve-out. And it goes to a real fundamental question. Yes, small businesses, SMEs, and large businesses compete differently. Does that mean then that we've got two options? Do we do, as the letter in front of Sheila says, do we give them a special dispensation? Or do we try and set the rules so that they apply to everyone and then see what happens? In other words, do we protect individual competitors, or do we protect the process of competition as itself? Pretty interesting question, and it's obviously one that the Commission here is grappling with as well. Because it is. I mean, the first one there, the letter that Sheila referred to is sitting on her desk, is exactly this sort of argument. We're about to get swallowed up by, we're only the small fry and we're going to get swallowed up by someone else. Who's going to get swallowed up by someone else? And for that reason, we need to be protected, we need to be looked after. Well, my message is very simple. Good competition laws, and Malaysia's are well-constructed competition laws, good competition laws will actually help small businesses. They will not hurt them, and they do not need specialised exemptions by and large to deal with them. Let's have a look at this. Let's have a look at this first of all. I said before, we need to think about how does this affect your own firm and how does it affect the sector as a whole? Well, first of all, let's think about how does it affect my own business. There's not a lot known about how much goes on in small businesses, but here's a couple of stories. The United Kingdom has one of the few countries that actually looked at this issue about competition issues and small businesses. And about a third of all businesses in the United Kingdom, if you ask them, will tell you that they have been the victim of an anti-competitive practice. What's an anti-competitive practice? I'll give you an example from my own experience. I used to run a small business advisory centre, helping people start their own business. Most of them were self-employed micro businesses. And I helped one man who took cigarette lighters, just an average cigarette lighter, you know, the sort of thing you pull out. I don't smoke, so it's a little bit alien to me, but cigarette lighters. And he would buy them, get them embossed, get a logo, a company's logo on them, and then sell them to that company. So, for example, a hotel sells cigarettes. He would go to them and say, I can supply you with cigarette lighters with your hotel logo on them, and they'll cost you this much. Very simple business, very, very small capital outlay, literally a couple of thousand Australian dollars. Not much at all. And I came back to see him about 2 months after he started, and I said, how's it going? And he said, well, my competitors are people like me. They've all been unemployed, and we've all decided to do cigarette embossing because it's very cheap, simple, you don't need any technical skills. And he said, I'm about to quit. What happened? And he said, well, these are the sorts of things that happened to me. One of my competitors rang up the yellow pages, pretended to be me, and cancelled my listing in the phone book. One of my other competitors would ring up the hotels that I was servicing and tell them that I wasn't interested in selling to them anymore, and they would offer to take up the contract for them. Basically, he said, this place is full of cheats and liars, and everywhere I go, these people are trying to drive me out of business. And that's the sort of thing that happens at a very individual scale. That's essentially anti-competitive, misleading, deceptive conduct about where businesses drive each other out of the wall. Now, they're not doing it by fair means. They're not doing it because they're selling a better product or they're selling it cheaper and the customers want it. They're cheating and lying and doing all sorts of dirty tricks to get him out of business. And that's the sort of thing that is illegal under a competition law. And that's the sort of protection that SMEs can get from a competition law. A third of businesses in Britain are subject to the same report getting the same sort of thing. Most of the time, though, they just say, well, it's not much point doing anything about it, I'm just going to deal with it myself. It happens, and it happens a lot to individual businesses. And many of them don't know that they can turn to the regulator, to the competition agency, called the Office of Fair Trading, and deal with it over there. Competition laws, by the way, don't actually cover business-to-business contracts, but lots of businesses think they do. The other ones that they do complain, false and misleading claims from other businesses. Our cigarette lighter man all over again, happening time and time again. Businesses complaining that their supplier won't sell to them, or they've asked a supplier for goods and the supplier won't make them available. Sometimes it's about simple things. What are the rules about advertising? What are the rules about pricing? When do I have to give my customers a refund? Scams, frauds, cheats. There are plenty of those out in the business world preying on other business operators as well. And then we also have, from time to time, a number of complaints about misuse of market power as well, which I haven't put up there because it's not as common as that. And in our experience, most of the small businesses don't come to us because they're not aware that they have the right to come to us, and they often find it a little bit difficult, for example, when they do, to give us evidence. They'll tell us they've got a problem, but they won't come to us with evidence about what the problem is. Very simple lesson here. If you're subject to anti-competitive behaviour, you need to think about collecting evidence and making it clear to people what it is. Most businesses actually, if they have a problem, want to be able to sort it out with the other business as well. They want to try and sort it out and get back to doing business if they possibly can as well. The individual experience of businesses, though, is not that great. I gave you a figure there for how many Australian businesses contacted us. Not many. I gave you a UK figure that said a lot more are aware of things going on in their industry, but decided not to do anything about it. So there are two things to take away from that. First of all, that for many, many small businesses, most of them in fact, competition laws don't have a direct impact on them day to day. So it's not going to change the way you do business, by and large. It's not going to change the way you do business. The other thing, though, is that if you do become aware of anti-competitive practices, then there is plenty of scope for businesses to tell the competition regulator what's going on, and in many cases, they're not always doing that. Now, what about the big picture? What's happening to businesses as a whole? And I think one of the concerns here is this issue that a competition law might be used by big business to drag out small business. It might be used by big business to effectively threaten small businesses or to make their life harder, because big businesses have legal departments, they have the advice, they know how to use the rules in a way that small businesses don't. This was again one of the questions that Sheila put up on one of her slides. Is a competition law going to help us or is it going to hurt us? And if you're worried about this, just think about this. Other countries are having the same issues. Hong Kong has just introduced a competition ordinance, and their concern is exactly the same. In Hong Kong, the strongest opponents of a competition law were the small businesses because they thought that what it's going to do is drive them out of business. Well, let me tell you what happened to us when we did it. We've had a competition law for about 40 years, but for the first 20 years, it by and large didn't cover most small businesses. For the first 20 years, it only largely covered large firms. It left out unincorporated businesses, it left out sole proprietors, partnerships, it left out, for example, not only unincorporated entities, but also things like the professions, many doctors' practices, accountancy practices, most of those areas. And in many countries, like Australia, professional practices are one of the biggest single groups of small businesses around. It basically left out all the micro businesses, because most micro businesses are unincorporated and they tend to either be professions or they tend to be tradespeople. For the first 20 years, for a variety of reasons relating to our constitutional arrangements, they largely weren't covered in our competition law. And then in 1995, we decided to extend the law to cover them. And that's a really interesting issue. We had the law in place, and then we decided to extend it to most of the micro and small businesses. And as you can imagine, we had an awful lot of groups saying this is going to be the end of the world for us. This is going to create all sorts of problems for us. And it also covered, again, another one that Sheila mentioned when she talked about the floriculturalists in the Cameron Highlands, this issue about what happens to very small businesses. We've been used to sharing prices. We've been used to giving that sort of information out and agreeing amongst ourselves on prices. If you ban that, how is that going to affect us? Well, this is what happened. Once we introduced competition law, over the next 10 years, the number of small and micro businesses almost doubled. I've hopped ahead a slide here because I'm going to come back to that one. What it did is it made a major change, and it made a major change for the better. Now, I'm not going to claim that competition law is the only reason why the number of small businesses in our country doubled in the 10 years after the introduction of that law, but it certainly didn't hurt. It certainly didn't hurt. If you want to see those figures, that's what they are. The total number of SMEs grew substantially, and more importantly, micro businesses, self-employed people, professionals, small retail shops, all of those didn't collapse. They weren't driven out of business by big firms. In fact, they've taken more space. There is now a bigger proportion of micro businesses than there used to be, and there is a bigger number of small businesses than there ever used to be in our country. A very simple lesson there. Competition laws can make a big difference. And the other thing to remember is that our laws have actually been used not only to, in the big picture sense, but they've also been about helping businesses individually. Here are some examples of just in the last three years alone of some of the things that a competition law can be used to help small businesses. Much of the discussion up until now has been about, if we have a law, isn't it about big versus small? Isn't it about what happens to small compared to large enterprises? Well, competition laws are also about helping small businesses when the competition agency turns around and says, this law also works to protect small businesses. And the Malaysian law is structured in a way that can also protect small businesses as well as applying to them. It's the same as in Australia. So in Australia, for example, in the last few years, 2 years ago, we won $3 million, that's roughly just over 9 million ringgit, of course, in damages from a franchisor that had basically tried to drive a number of individual franchisees out of business. We also issued an infringement notice, which is a penalty, a bit like a speeding fine or a parking ticket, to a business that falsely claimed to be a member of an industry association. We have told industry associations that we will use the law when people turn up, businesses falsely claim to be a member of your industry association. You can prosecute them under the law, and we may also, if we think that there's a bigger problem there as well. So again, the law can be used to protect individual SMEs as well as industry associations as well. We've used it against firms that prey on SMEs. There are a lot of fraudsters, a lot of people trying to con money out of small businesses by fairly dubious practices. So in this case, the fake Yellow Pages phone directory, a firm would issue invoices, send them out to businesses and say, you owe us for this listing in the phone book. And it wasn't the real Yellow Pages, but it looked an awful lot like it. And if you don't pay up, we'll take you to court. So many of those businesses obviously contacted us and saying, I don't recall ever being part of this directory, I don't ever recall agreeing to take this advertisement out. And it's a simple reason, they never had. So we found the firm, it was a European firm, we prosecuted them in the Australian courts, and we got a sizable Senate penalty against them for doing that. We've done it against other businesses, We've done it against other businesses here, publishing companies that have written out to businesses and sent them fake invoices and said, you owe us, for advertisements that have never appeared. And for businesses that have also written out to SMEs and targeted them and said, you need to buy these signs from us by law. Completely false, completely fake. So businesses can get used to the idea that the competition regulator can sometimes be used if they've got a complaint against another firm, as well as if there is someone preying on small businesses as a whole as well. The difference, I think, probably between where you're sitting at the moment and where we're sitting is that after 20 years, we know what our laws can do and what they can't do. They're not perfect, but by and large, most of our small business associations actually think that the competition law works to protect them overall. It has led to changes. It has meant that industry associations have had to change some of their practices. But, as you can see there, our national body of small business groups today says that without a competition law, we would actually be worse off than if we didn't have one. And that's very much the experience. In fact, if you think about it today, you're thinking, is this law going to hurt or help us? 20 years down the track, if the Australian experience is any example, you may be well at the point of saying this is a really important law for us to protect us as well. Now, let me just give you a picture about this in practice. Has anyone heard about Parisian taxis? Taxis in Paris. What are we talking about? Taxis in Paris. Well, just after World War II, the French government decided that it would protect small businesses in Paris by putting limits on taxi licences. It was just after the war, the usual sort of complaints. It's hard to get back on our feet, it's hard to survive, we need special protection. We don't want more competitors in here. And the French government agreed. And what happened was that they basically froze the number of taxi licences in Paris. And they never changed the number. And what it meant was that if you were very lucky in 1946 and you had a taxi licence in Paris, you were one of only a very limited number of people that had them. And for the next 50 years, next 60 years, no one else was allowed to get a taxi licence. It worked brilliantly for that very small number of business owners. They had an absolute fortune. They had a monopoly almost, an oligopoly. But no one else. Did it help the tourism industry? No, because as tourist numbers grew, there weren't enough taxis. Did it help the ordinary Parisian? No, because there were no longer enough taxis as the general population of Paris grew. Did it help other people who thought, I want to be a taxi driver? No. Did it help entrepreneurs who came in and said, I can offer private hire services, I can offer a new way of doing this that is cheaper and better for customers? No, because they weren't allowed to. And that's what happens when you protect individual competitors. You get a very small privileged group of people who profit at the expense of everyone else. And that doesn't mean that you don't think about what small businesses need, but you do need to think about the bigger picture as well. And quite frankly, my sympathy is on the entrepreneurs who want to come into the French market and get a taxi licence or offer a chauffeur service. It's not about those people who are lucky enough to have their grandparents be given a licence and never have to worry about it ever since again. That is really unfair to every other small business operator. Now I'm going to skip here and just a comment I just want to make. I realise time's running over, so I want to just make a final point for small business associations and small business representatives here. It is not the easiest thing in the world for many competition regulators to deal with the small business sector. So you need to think about what you're doing with the regulator and how you can help them do their job. It's not easy because for a variety of reasons. First of all, this is all new. This is not something anyone has dealt with in this country before, so it's a bit of trying it as you go. Secondly, you've got two different worldviews. You've got the worldview of the business operator and you've got the worldview of the lawyer, economist, public administrator. And they need to talk to each other to understand what each other's goals are and also how they work as well. Small businesses sometimes spend a lot of time complaining about something doesn't work rather than making suggestions about how it can be fixed. And small business associations also need to talk to regulators to make it clear about these are the problems we are facing and this is our situation as it stands today. Don't expect that the government will always understand your position and will always be able to fix it unless you make the effort to explain it to them clearly, to give them their options and to help them work out how this should work out. The chance here when you've got a new national law is a really important one and is a really good opportunity to do things together that will actually help the sector. But you've got to be a bit proactive about it. We, for example, every couple of months we have our peak group of small business associations sit down in a room with our chairman and our commissioners and tell us about what's going on, what their problems are and their questions about how the law is working. But they also take the time to talk to our staff a lot and to our individual commissioners like myself and explain their problems, their situations, to tell us about areas they think we might be able to help them with as well. So I want to conclude with some suggestions about helping the regulator as well. It's not a one-way street. The more you can do to help the regulator understand, the better it will be as well. So I'm conscious of time and I think I've probably taken enough of that. So I will, and we've got time for questions, so I'll conclude on that point and thank you very much.
My question is on this competition law. My perceived concern is on the asymmetry of information. Once we open up the market, is there a possibility of some industry association not telling the consumer what the price of the market? And so there will be an issue of asymmetry of information. Some information might be misinformation, or there is a lack of information, or there's no transparency of information. So the customer or the buyer has to be very intelligent. They have to do a lot of their homework to find out the best price for them, instead of now where we can just go to the association, for example, where there's some price information that can gather. Another question is, does the association of the industry allow some form of indicative price, not a fixed price, but an indicative price for the public to have some form of indication of what the price would be? My third question would be, if there's a complaint, where do we go now? On SMEs or on other businesses. Right now we go to the Ministry of Domestic Trade. In the future, do we have to separate what kind of a complaint that we need to go to MYCC, or what kind of complaint do we go to the Ministry of Domestic Trade? Thank you.
Okay, I'll try to address the three questions, and then Dr. Michael will give his perspective of what he thinks it should be. Price information. Well, as I explained in my slides, I know this is a real problem for SMEs. Where do they go to get prices? And how would consumers know, where to go and get these prices? So we were thinking of like, a third party which collects information and disseminates to whoever's interested in those kind of pricing. But I would also think, maybe I'm wrong, but maybe SMEs and small businesses actually should now educate themselves as to the pricing mechanism that they need to put in place. They need to know what is the cost, what are the inputs, the cost factors for all of the inputs that go into their products, and the kind of pricing that they can publish. Because to me, or I mean maybe this is a misconception also, I'm not sure, you can display your prices individually. But what I'm saying is, as a group, as an association, you do not disseminate that pricing information because your association is actually made up of competitors. But again, you know, there are a lot of arguments otherwise that, you know, small businesses feel that what's wrong in sharing information because we are all in the same group, you know. Okay, maybe Dr. Michael, you may want to, you may want to jump on that.
Yeah. Two quick comments. First of all, in terms of industry associations and business groups sharing pricing information, in Australia the approach is generally that industry associations can share information, but there is a very fine line between price fixing and sharing of information, and you have to be very, very careful. In fact, our guidelines to industry associations say that you really should have a lawyer in the room when you have those discussions to make sure that you don't fall on the wrong side of the law. Some industry associations have recommended retail prices, for example. This is a price that we suggest you might want to sell it at. That falls within the law in Australia, but we have also prosecuted industry groups and industry groups that have tried to enforce it. They've turned around and said, you must sell it at that price. Exactly. That is price fixing, as well as a number of other evils. And so there's a fine line between saying, this is the price you might want to think about, but it's your decision, not ours. So that's the first thing to bear in mind. The second one to think about is it is the pointy end of economic theory. Economists would argue the more information you have, the better a consumer can make a choice. However, at the same time, you can also provide information in such a way that it actually is anti-competitive as well. We've had a number of industries, and we are investigating some industries where information is provided which we think runs very close to breaking the law. For example, industry associations collect pricing information, but they only make it available to the firms that give them that information, not to the general public, not to other businesses. Then we think that that falls very closely on the line of actually fixing or sharing prices between each other. So the golden rule we say to most businesses, most industry associations is it's safer not to do it. It's much safer not to do it. If you do it, be wary of the fact that you may be crossing it. And finally, also, it encourages, consumers should be encouraged to shop around themselves and get their own prices more. The more they do, the more chances are to get a better price for themselves anyway.
Thank you, Dr. Banker. I think because we are starting off, I think consumers have been pampered, as you know, so they don't want to shop around for prices. They want to be given the prices. When I speak to consumers, that's what they tell me. They say, why do you want to interfere with the way things have been, Yeah. Things have been in place, so it's convenient for us to know what's the pricing, what is the recommended price. And coming back to the recommended retail price that Dr. Michael Schaefer mentioned, even in our guidelines, we have said RRP, recommended retail price, is okay unless it becomes a reference point. And that's the fine line that we are talking about, when it falls into price fixing. A recommended retail price actually goes into the area of price fixing, okay? The third question was, if there is a complaint, where do we go? If it is a complaint related to competition issues, then you come to Ministry of Domestic Trade. If it is a complaint of a business to consumer nature, then go to the Ministry of Domestic Trade. But whatever complaints that come to us, we will channel it. If it is not within the jurisdiction, of MyCC, we will channel it to the ministries concerned.
I would like to ask a few questions. First thing, on the Association of the Florists in Cameron Highland, may I know how many members are there in this association?
150,
150.
yes.
So are they price fixing or they are just merely recommending prices?
It was price fixing. It was a statement to say that all prices will increase by 10%.
Does it stop his customer from asking discount?
Sorry?
Can their customer ask discount?
No discounts, fixed price.
You sure?
Yes.
As far as I know, Malaysian consumers or businessmen are good bargain hunters. Nobody pay fixed price. I think those people who are in the business know that even up to 10 cents, they ask discount. And if they don't give discount, they will delay payments. In a way, you save money by paying them later. I think we came from the Association of Jewelers and Goldsmith, and supposedly we are giving recommended retail price. And as far as I know, we have about 2,000 members, and nobody actually sell according to that price. And actually, consumers ask discount every day. But we are facing a problem right now because international gold price ups and down. And for the last 3 days, down by about 2%. If we are not able to give recommended retail price even, we have problem. Because some retailer may not adjust the price lower when international market price has gone down. And a lot of consumer will still buy at a very high price. I feel that association should be able to give recommended retail price if they are not enforcing it, stuffing it down the throat of the customers. And if customers are allowed to ask for discount, then isn't it valid for association to continue to give recommended retail price?
I think I did mention that recommended retail prices are okay unless it becomes a reference point and where there's no flexibility for members to move around with the prices.
So you're saying that if we can prove that each consumer can buy at different price, although we give one standard recommended retail price, and we can continue to give it, are you saying that?
Is that?
Can I give an example of something?
If I walk into any jeweler store right now, and I can ask for 1 ringgit, 2 ringgit, 10 ringgit, 100 ringgit discount, does it mean that the association can continue to give recommended retail price? Because if I walk into Petronas station and Esso Petro station, or even Shell station, I cannot ask discount. But if I go to many retail store, I can ask for discount. Isn't it? I think I went to Australia, I'm not given the liberty to ask for discount, because they look at me and think, oh, you are cheap when you ask for discount. But in Malaysia, we have nice Indian, nice Malay customers and good Chinese customers who won't mind standing in front of you asking for extra 2 ringgit discount for 1 hour. If you don't give it to them, they'll continue to sit there. So I think Malaysia is a little bit different from Singapore. If you go to Singapore, I cannot remember the last time I asked for discount, But in Malaysia, I have the liberty to ask for discount everywhere. So if the association can prove that consumer have the liberty to ask for discount from their members, isn't it the association can be allowed to give or publish recommended retail price?
Yep.
Yeah.
Okay.
I think we've already made the point, although I'm obviously not making the rules here in Malaysia. If the recommended retail price is literally just at a recommended price and you can walk into the store and negotiate or so forth, then on the surface that's not a problem at all. Of course, as you pointed out, in places like Singapore and Australia, the custom is that shops tend to just set a price and
So they need the competition law more than Malaysian.
It's when all of a sudden you try to enforce it and say you can't deviate from it that creates the problem. We've had many times where customers have rung up and said, I've tried to negotiate a discount, and the store has told me, or the professional service provider sometimes, has said, we're not allowed to give discounts because our industry association has said that we can't. That's when our ears prick up, and that's when it becomes a problem, a very big problem. It's also been the case sometimes when other businesses have complained as well and said that the price is fixed, or I've tried to sell it cheaper, I want to sell it cheaper, and I've been told that if I sell it cheaper, they will cut off supplies to me. That's fixing the market, for example.
I see. So we can still continue to give recommended retail price, you are saying?
Recommended retail prices, which becomes a point of reference. Again, I'm saying
Okay.
it borders between recommending and fixing your prices. So I know I buy a lot of gold, and I get discounts only on workmanship. I don't get a discount on the price of gold because what I'm told is that this is the price fixed by the association.
A very important info for you today is actually you can ask for,
Okay.
but you have forgotten. But they will not tell you that you can, because actually that's the free market, isn't it?
Yeah.
Okay, thank you very much.
Thank you.
Hi, good morning. My name is Sophia. I actually represent the franchise industry. I think it's a similar case. I spoke to Dr. Shepherd earlier. Was the competition law prepared in consideration of the Franchise Act existing in Malaysia? Because at the end of the day, again, which prevail? Because in the Franchise Act, franchisors have the right and authority to fix prices for all the franchisee outlets. And most of the time, the franchisees are the SMEs. So, what issue can arise from such a situation? It's not so much of a question, but it's to highlight that. And the other thing, I need to compliment Dr. Sheffer on his last slide, which I hope the other government representative here will take into consideration to involve industry players to actually share before a certain policies is put into place. I think the industry players agree. This is why I think a lot of forum and dialogues are needed before policies are put into place. I hope the GLCs and the government will take this into consideration. Thank you.
Well, I think a lot of consultation was done before the policy was put in place. We consulted the franchise association. Then it was under the Ministry of Kapuna, it was it? Yeah. The franchise development division in the ministry was also part of the consultative process, and we have taken into consideration a number of issues in the franchise industry. And we will also be issuing guidelines on franchise industry, franchise issues. So before the franchise will actually be touching on some of the IP issues, right? So we will be issuing guidelines on IP, and IP will involve the franchise industry. So before we put out those guidelines, we will also be calling for consultation, and we will be considering some
Just
of
now
the issues.
I heard about the person mentioned about the manufacturer who indicate certain price to the distributor, and also the friends also mentioned about the when he fixed certain price or sign agreement with the distributor in different regions, Personally, I should think they should be allowed to sign agreement as an individual manufacturer. If we were to look at the MYCC, it's more on the collective manufacturers rather than individual manufacturer. So individual manufacturer, they should be allowed to fix the price. Most of the stationery or many products, whether it's from German or from Europeans, they have fixed the price for the distributor to sell. Their price is fixed, but they are the individual manufacturer. So now the question is not individual manufacturer fixing the price for the distributor to sell. It's more on the collective manufacturer. If you look at the price fixing, here is prohibited to collectively agree to fix. Another one on the sharing market, enterprises. It refers to enterprises to share market on the source of surprise. It's not individual, because manufacturer, they should set a price for their distributor to sell and how much discount they can give to the consumer or another retailers. So it's very common, internationally. Many products like Stedtler or even from Faber-Castell, they fix a price. Distributor, you can give discount 30% to your retailer, and the retailer will give another certain percentage to the customer. So individual manufacturer should not be prosecuted unless they fix with other manufacturers together. Thank you.
But that's basically price fixing, right? You do not give the flexibility to your retailer to...
As an individual manufacturer, I don't think it's a price fixing. Because you look at the percentage, they control the market is very small. Unless you are talking about like Microsoft, it's maybe slightly different. You have to look into the monopoly like Microsoft, or maybe they are too powerful, and so it's a factor to be considered. Because if you look at the market throughout Malaysia, Western Europe, most of the main branded distributor, they fix the price. You go there, you buy this price. You go to another shop, you buy at the same price, because the price is fixed. You buy the watercolor, color pencil of Stedtler, the price is fixed. It's fixed already. So they have to be allowed to fix the price. You can walk into any bookshop, you buy the branded German brand color pencil, the price is fixed already. So they are not infringing the MICC Act. Unless you say all the manufacturers from Faber-Castell or Stedtler, they fix the price, then it's a different story. Individual manufacturer, they are not infringing the MYCC Act.
No, but it doesn't matter whether you're an individual manufacturer or manufacturer as a whole. I mean, jointly agreeing on a price. If you remember the slide that I showed you, the cartel-like activities under Section 4.2, price fixing is one of the infringements under the Act. So even if you are fixing prices individually or not, that is an infringement under the Act.
So are you saying all the fixed price in all the shop now, by next year, you are going to prosecute them?
No, you are telling me that the manufacturer has fixed the price to the retailer.
Yes, to the distributor and also
the retailer.
Yes.
Okay.
They are fixing the price.
So it means that the retailer and the distributor do not have any margin to reduce their prices. They have to follow the price that has been given by the manufacturer.
Of course, they are saying this is recommended price.
Yeah,
Most of the product, whether it's from German or from Western country, when they set up a regional distributor, they sell to the wholesaler at this price, and also they give another percentage of discount for wholesaler to sell to the retailers. So are they infringing MYCC?
No, if there's no price fixing,
So
there's nothing wrong.
Yeah, as an individual supplier or
Because
manufacturer.
I just heard you saying that they are giving them discounts, allowing them to work on some discounts.
Yes,
Okay, so that's not price fixing?
and also the recommended retail price, they are fixed at that price.
Okay, so recommended retail price is fixed.
It's fixed.
It's fixed, so that means it's a fixed price.
So when you walk into different
Because
shops,
you're telling me it is a recommended retail price, and yet it is fixed.
yes, it's fixed.
So,
Yes, it's fixed.
so it cannot be a recommended retail price. Because a recommended retail price means there's a price that you recommend, and then the retailer is actually free to fix the prices as he thinks he wishes to.
So,
Okay, but if the recommended retail price becomes a fixed price, then you are infringing the law.
okay, thank you.
I come from a field with arts, representing the arts people. So my question is, it was very interesting when you showed the pyramid just now that the micro business represents the majority of the pyramid. And I today like to believe that because of the majority number of the micro business, it really supports the economy. And of course, the large entity company get the supports from the micro and also SMEs. So I think it's a very good platform because a lot of questions played in my mind and also people's that I am working with within our industry is about the price setting. So specifically, I am a photographer. So in Malaysia, we don't have any bodies that's setting up the price. And every time, like what that Mr. said, Malaysian consumers are really good in bargain hunting. So every time we produce the price list or our rate, first thing they will ask, okay, is there any discounts? So the situation I feel as a service provider, and because we produce a product and also arts value on our end products, it's like the same like the situation as an employee in any organization. Say for example, their salary is fixed at 10,000 ringgit per month, and suddenly 1 month the boss is asking, okay, can I have a discount in paying your salary this month because we have whatever the problem is. So I think that situation is the same. So how MYCC want to address this kind of situation? Because our problem is to educate the consumer as well when we are fixing the price. Like in the photography industry, photographers can set the price from as low as 500 ringgit to over 50,000 ringgit depending on their markets, target markets, but there is no limitation setting up price level. So that's always a concern, how we want to minimum the price setting, because 500 ringgit is very, very low because the equipment we're using is very, very expensive. And of course, we are not addressing about the currency exchange and stuff when we are buying our equipment. So is there any ways for MYCC to address the issue? Thank you.
You're talking about setting minimum prices?
Minimum prices, yes.
And maximum?
I doubt about the maximum because it seems like there is no ceiling, and some group of consumer or clients, they are willing to pay because you know the behavior of the clients when you are paying cheap products, so most of the time they don't realize on that, but certain groups of clients, they will value the services or products when you are setting at a higher price. So people always say when you pay cheap, you get monkey. So that's the problem that we are facing. And setting up the minimum is not as low as 500, maybe 2,500, 3,000, because we are also professionals in delivering our work.
I think also it goes down back to the ability of consumers to shop around for the best available service, okay? But if you are telling me that you are setting minimum prices in order to protect your industry. Are you coming from an association? On individual. Individual?
I'm sorry, there is no association, formal associations for the photographers that as far as I'm concerned, because there's lots of
Thanks, sorry.
There is a lot of small group of association, but it's not representing the overall
Okay.
of the
So
practitioner.
these small groups are actually getting together.
They're
and-
getting together, but never address on the price. Never
Yeah, but
address
so
on-
you are actually sharing information in that sense to say that let's all, have a minimum
Yes.
price
Yes.
so that, you are protecting
Yeah.
sort of your industry.
Like, I'm not sure, Dr. Michael, if you're aware, like in Australia, there is a group of photographers, they are into one association and it's official, so everyone will have to work within the minimum number of charges, which I know that in Hong Kong they have, but we don't have that here in Malaysia.
Because in Australia, basically, minimum and maximum prices are both a problem ultimately.
It's the same here, minimum and maximum, because they become a point of reference then,
Here's a simple way to think about it. Price fixing is illegal. Price fixing can take many forms. One is to say you must sell it at this price, but it can also take other forms, such as saying you may not sell it below this price, or you must not sell it above that price. They're all forms of price fixing. So you just need to get that clear in your head. I think that's probably
Yeah.
the context here too.
Yeah. Okay, have I addressed your issue? I think
How are we going for time?